Okay, here we go. Here we go. For those of you who are in line, thanks for your patience. And there's a lot of seats empty up here in the front. They're the best seats in the house. That's where we sign autographs. I'm Rory Little, and I'm a professor here. Been here since 1993, which is not nearly as long as some of our other panelists. And I'm really happy to welcome you all to I think it's the 26th annual Supreme Court Review and Preview here at UCLSF, not Hastings. Used to be Hastings, the oldest law school west of the Mississippi, UCLSF. And we're trying to figure out how to say that fast. We have an amazing lineup to talk about these cases, but I have to give a few preliminaries before we do the substance of the panel. So it takes a village to run a law school or something like that. And I am grateful to all of the people who have contributed to making this event happen. We have staff, we have students, we have faculty. All your servers are students. I want to particularly thank Morris Ratner, who's the provost and academic dean for the school, and his assistant Cynthia Diaz and Ashley Jadia. I don't know if they're still here. Cynthia, are you here? Ashley, they were back there running the show. There's Ashley. Thank you for your help. They put in tons of hours on making this happen. Mustafa and everybody with the facilities who has to set up 230 chairs in here. The IT staff who put up microphones. We have 2 microphones in the middle for questions from the audience at the end. And the student organizations that co-sponsor the event. Students are, of course, vital to the lifeblood of the school, and the organizations that they run are really important for what we do here. So I'm really happy to be able to thank 4 of these organizations in particular. So first, the University of California, San Francisco Law Journal and its managing editor, and who also is my criminal law TA, Calum Kelly. Calum, are you here? There he is. Thank you to the Law Journal members who did a lot of work to help set this up. The other flagship law journal, the Constitutional Law Quarterly, and its editor-in-chief, Megan Stupi. Megan, where are you? There she is. Former criminal law student. The CLQ is the only journal here, as far as I know, that publishes still in print, although I hear that the Law Journal is trying to go back into competition in print either this year or next year. So I want to say 3 cheers for that, because I think print copies are very important for the study of the law for lots of reasons, including that you can carry them on the subway and things like that. CLQ was also the first journal that I ever heard of when I was on the East Coast. I was clerking at the Supreme Court in 1984. And I didn't know anything about Hastings, but I knew about the Con Law Quarterly, the CLQ, because it had the title Constitutional Law in its subject matter. The CLQ is consistently and continues to be a source of excellent constitutional law scholarship, and I want to thank them in particular. I also want to thank the student chapters of the Federalist Society, their president and vice president, Ash Armand and Maxwell Zell. Maxwell Zell, where are you guys? There they are, right there. And the student chapter of the American Constitution Society and their president, Julie Hunter. Julie, are you here? There she is. So thank you. Each of these groups have really contributed, not just from their budgets, which they have done for the food that you're eating, but also for all of the other volunteer help behind the scene and hanging up of posters and things like that. Anybody else here from either any of those 4 groups? If you're associated with any of those 4 groups and you're able to, please stand and receive our thanks. HLJ, come on, or CLQ, side. Okay. Do we have any 1Ls here? If you're a 1L, raise your hand. Those people that were just standing are the folks you should talk to. All right, thank you for being here. All right, just a little bit of substance and then we'll do some proper introductions. Last term, the US Supreme Court decided 59 cases with what we call merits decisions. A merits decision means the case was granted review, fully briefed by the parties, as well as usually these days dozens of amicus, and then opinions issue after a full oral argument. So 59 cases by merits decision. Now, undoubtedly, many of these were momentous historic decisions about which you're going to hear more momentarily. But let me take a little prerogative of the moderator to make a controversial point here. The 9 justices on our Supreme Court have the easiest job of all of American judiciary. 59 cases averages to 7 cases per justice. What judge of any other court in America wouldn't love to have a workload that is just 7 cases a year? Judge Beyer, your workload is slightly higher than 7 cases. Even if you count cert petitions, which they deny, hundreds of every year, they really don't have to work that hard. They have 4 law clerks from the best law schools in the country, 4 law clerks per judge, 5 if you're the Chief Justice. They get paid $275,000 a year, which is not as much as a law firm partner, but not chicken feed. They usually have at least 2 reasoned decisions prior to them confronting the issues. That is, other judges have worked it through before they get it. And they have the best lawyers briefing those cases and arguing in front of them. And they have the summers off. In fact, their first conference since last July 1st, when they issued their last opinion, their first conference is this Friday. And this Friday, they will grant review in probably 10 more cases. They've already granted review in 28 cases for the coming term. The term begins on October, the first Monday in October. That is by federal statute, although it dates all the way back to the first term, which just happened to be a Monday. First Monday in October. So right now we're finishing October term 23. And October term 24 will start next Monday when they gavel in the first oral argument. So I guess what I'm saying is I think they could do more with their 7 cases a year. They could do more than 7 cases. One of the problems is that there are far more separate opinions issued per case, as well as more pages per decision than in the past. So here's a sample of what the first 4 cases that we'll talk about today look like. This is over 400 pages, double-sided, printed out, so that I can read them wherever I want to and underline and things like that. Among these 4 cases are 18 separate opinions, 18 separate opinions. That's 4 separate opinions per court. This is very confusing and difficult to interpret for lawyers who have to use these cases in the future and lower court judges who have to decide how they should apply. That many separate opinions is very difficult for anyone to digest, let alone agree on what it is the court actually held. Justice Kagan, this past summer at the 9th Circuit Judicial Conference, actually recommended, and this is a quote, you should ignore concurrences. You should ignore concurrences. Maybe that's because she doesn't write very many. She does it. She writes either dissents or majority opinions, and otherwise she keeps her mouth shut. But the other judges like to write concurrences. In a lot of cases, Amy Coney Barrett, Ketanji Brown Jackson, the 2 newest justices on the court, write a lot of separate opinions. And by the way, they both show the value of life tenure. There is some value to life tenure, which is independence. Amy Coney Barrett did not have a hard time this year saying when she disagreed with her fellow appointees from President Trump. Ketanji Brown Jackson dissented or concurred separately and apart from some of the liberal justices in various cases. One case in particular called Erlinger, which no one's heard of, which I will say is the sleeper decision of the term if I get to me at the end of this panel. She wrote a concurrence with the conservative judges, while Amy Coney Barrett wrote a dissent for the liberal judges. So there's some independence, there's separate opinions, and maybe Justice Kagan is right. If she is right, you should ignore concurrences, then the justices could write less and do more. I'll be teaching con law this coming spring if you want to hear more from me on this topic. We will come back to the cases that are granted for review, and I'll talk to you about some that you can listen to on live, right? They now broadcast their arguments live. It's a byproduct of the pandemic, but they've kept it starting at 7 a.m. on Monday morning, October 7th. Now, to the merits. We have a particularly esteemed panel of scholars here to talk with us today about some of these cases. We're not going to cover the entire term, by the way. We couldn't cover even 59 decisions in 90 minutes, let alone 28 that are still granted for next term. First, we have the Honorable Carlos T. Bea. who I am personally thrilled to have present here. Judge Bea is an amazing jurist and an amazing lawyer. He has done more law in one lifetime than most of us will do in three. He has served on the U.S. Court of Appeals for the Ninth Circuit for over 2 decades, since 2003. Judge Bea was one of the first Latino judges to be appointed to the Ninth Circuit, and indeed to all of our federal circuits. And I have to say it's an honor to have him here during National Hispanic Heritage Month. So thank you, Judge Bea. I have more to say. He previously served as a Superior Court judge for 13 years prior to being appointed to the federal bench. And prior to that, he practiced law in the Bay Area for over 30 years. So you can see it's a long and storied legal career. Here are 2 other fun facts about Carlos Bea for all of you here, if you haven't already read his bio. He was born in Spain and emigrated initially to Cuba. He played on Cuba's Olympic basketball team in the 1952 Olympics, which I think is, I think that's the coolest thing you're going to hear today. And earlier this year, Judge Bea and his family celebrated the 90th anniversary of his birth. So please, I'm a big fan of Judge Bea's. Thank you for being here. Okay, next we have a panelist who really needs no local introduction, particularly not when you come down those stairs and you see that we are now sitting in the David Faigman Auditorium. David Faigman has served as our Chancellor and Dean for over 8 years, which by itself is a remarkable tenure. The average tenure of a law school dean in the United States is something like 2.5 years. So he's been here for 8 years, which means he has gone through one so-called re-election period. So he's really, really achieved the respect and honor of his colleagues here, as well as our board. He is the longest serving member of the faculty here at UCLSF. He joined the faculty in 1987, as he likes to say, when he was 10 years old. He first made his mark in academia, at least in my mind, as a constitutional law scholar. And when I first arrived here in 1993, I read his early articles on Madisonian constitutional theory. So whatever else you may know about David Faigman, he is a constitutional law scholar who, by all rights, belongs on this panel every year. He has published over 60 scholarly articles, essays, 3 books. His treatise on modern scientific evidence is relied upon by lawyers and courts, including the United States Supreme Court, more than once across the country. And then more recently, as you know, Dean Faigman, he has overseen, together with the other David, our CFO, David Seward, he has overseen the funding and construction of 2 new buildings and perhaps another 2 buildings soon. I'm looking for the David Seward Auditorium to be in one of the new buildings. I'm a fan of David's too. He and I joined here at the same year. It is an amazing accomplishment to preside over the funding and construction of 2 large buildings in downtown San Francisco at any point, let alone during a pandemic economy. So I have to say, David Faigman deserves our applause. And now I want to introduce to you the youngest member of our panel and one of the newer professors here at UCLSF, Prithika Balakrishnan. Prithika is our new criminal law scholar here, one of, 3 new criminal law scholars. So someone like me who's been doing this for 30 some years here, we're really happy to have Prithika with us here. She's a real lawyer who practiced law at the San Francisco Public Defender's Office for well over a decade. And she's a graduate of Stanford University and Yale Law School and has served as a Peace Corps volunteer as well as a union organizer in her early career. And so we're really happy to have Professor Balakrishnan here. I'm going to tell you how the panel's going to go, then I'm going to sit down and try to be quiet. We're going to begin with Supreme Court analysis by discussing the presidential immunity decision, United States versus Trump. Dean Faigman is going to open that discussion. We may all comment on that, but I think Judge Bea will initially have some things to say about that as well. Judge Baer will then present on three of the biggest decisions of the term, one which addresses the Chevron doctrine, one addresses gun possession, and one addresses homelessness. Again, the panelists will comment on each other's remarks as we go. After that, we will get to Professor Balakrishnan, who will talk about some constitutional criminal law decisions. And if we have time, I'm going to talk to you about the Erlinger case, the sleeper decision of the term, and a few cases set for oral argument. No matter what, we're going to stop with 10 to 15 minutes left for questions. Questions from the audience, and by that I mean questions. I don't mean long statements. I don't mean long speeches. I mean questions. There are microphones set up in the middle of the aisles here. If you have questions, if you're unable to reach one of these microphones, I think we're going to have somebody at least to pass around a hand mic. I'm not sure who that's going to be, but we'll see how that goes. And we will end precisely at 2 o'clock or whatever 90 minutes is from when we first stood up. So with that, I'm going to turn it over to Dean Faigman.
All right, thank you. So Erlinger might be the sleeper case. Trump versus United States is the nightmare case of the term. And I do think that Trump versus United States is a perfectly encapsulated style for what the court decided. The court granted cert on the question, quote, whether and if so, to what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office. And they concluded that under our constitutional structure of separated powers, the nature of presidential power requires that a former president have some immunity from criminal prosecution for official acts during his tenure in office, at least with respect to the president's exercise of his core constitutional powers, presumably those that are granted explicitly under Article 2 of the Constitution. This immunity must be absolute. As for his remaining official actions, he's also entitled to immunity. At the current stage of proceedings in this case, however, we need not and do not decide whether that immunity must be absolute or instead whether a presumptive immunity is sufficient. So that's what the court held. To say the least, that is an extraordinary holding, and it's probably equivalent to a Hail Mary pass that the Trump lawyers threw out. I don't think the Trump lawyers thought they could actually win that kind of argument, yet they somehow did by 6 votes on the Supreme Court. So the question you might be asking, especially for those who take constitutional law, is how do you get to this extraordinary result? And as you should know, there are certain basic principles of interpretation that courts use, whether it's the Ninth Circuit or the U.S. Supreme Court. They include text, original intent, precedent, and finally employing a functional analysis of the Constitution to effectuate the principles or values of the Constitution. So let's just consider those in turn. So the first potential basis for this remarkable ruling is the text. However, the text is silent on the issue of executive immunity, as the majority itself admitted. Indeed, the impeachment clause of the Constitution expressly recognizes the prospect of criminal prosecution of a former president for acts committed while in office. It provides that an official impeached and convicted by the Senate, quote, shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. That's Article 1, Section 3, Clause 7 of the Constitution. So text does not support the holding. The second ground is history or original intent, a favorite of at least 6 members of the present court. The majority that was in that ordinarily like original intent and history, they found that the history was at best indeterminate. Justice Sotomayor's dissent had no problem finding historical support for the proposition that, quote, former presidents are answerable to the criminal law for their official acts, unquote. To take just one example among many, many provided by Sotomayor, quote, Alexander Hamilton wrote in Federalist number 69 that former presidents would be liable to prosecution and punishment in the ordinary course of law, unquote. And according to Sotomayor, on the majority's view of history, she said, it seems history matters to this court only when it is convenient. citing Bruin, which is a Second Amendment case that relies exclusively on history and original intent. So a third ground is precedent. Well, does precedent support this extraordinary holding? As the court itself recognized, this holding was based not on precedent, since this issue was one of first impression. Although the court in Nixon versus Fitzgerald had granted presidents immunity from civil action for their official acts, and that's while they were serving as president, it had never reached the question of immunity for criminal acts for former presidents. Indeed, all of the opinions in Fitzgerald, if you read it, either explicitly or implicitly assume that no such immunity would apply to criminal acts committed by a former president. The remaining ground for supporting the court's holding was a functional analysis with the stated constitutional value, that of separation of powers. According to the majority, immunity, quote, is required to safeguard the independence and effective functioning of the executive branch, unquote. The court thus employed a balancing test, a test that most of the 6 members that joined in the majority have at different times rejected as an appropriate method for constitutional interpretation. For the court, effectuating separation of powers was the driving principle. The majority believes that allowing criminal prosecutions of former presidents will lead presidents to be timid and hesitating in their obligations under Article 2 of the Constitution, and in those areas delegated to them by Congress under Article 1, by which the president is obligated to, quote, take care that the laws be faithfully executed. So the concern there is that somehow presidents will be timid because they will fear after they have left office that they would be criminally prosecuted. But once again, I think the dissent has the better of the argument. First, it can be presumed that every president throughout history had themselves assumed that they would be subject to criminal prosecution when they left office. That was the understanding of the founders, and I think that was the understanding throughout history. And I don't think that Franklin Roosevelt or Abraham Lincoln or many other presidents could be accused of being timid or hesitating. Second, in straight up balancing between concerns over it being intrusive on the office of the president and the public interest in prosecuting criminal acts, once again, I think that the balance prefers the public interest in prosecuting crime when it's committed, even if it's committed in the Oval Office. Third, and not made as explicit in the dissenting opinion, but I believe the majority misunderstood the basic principle that is embodied in the separation of powers. That doctrine was not intended. It was not intended to give exclusive and final authority over the domains defined in Articles 1, 2, and 3. Instead, the fundamental principle embodied in the overriding value endemic in the Constitution is that of checks and balances. Every division of authority in the Constitution is about checks and balances. Whether it's federalism or it's separation of powers, it is about one authority, one sovereignty, checking the power of the others. Specifically, while there are areas in the Constitution that are exclusive and conclusive for each of the branches, they are very few and they are very limited. And the reason for this was captured by James Madison in a very famous statement in Federalist Number 51. And I always like to read it because this is what our Constitution is fundamentally about, and is the fundamental tenet that this Supreme Court missed in this case. Madison wrote, quote, "But what is government in self? But the greatest reflection on human nature. If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself." And that is the principle that this decision undermines and does not advance. And as Justice Sotomayor stated, quote, "There is a twisted irony in saying, as the majority does, that the person charged with taking care that the laws be faithfully executed can break them with impunity." Thank you.
Judge Bea, you have the right of first response if you want it.
I would love to respond if I fully understood the decision. But it's really groundbreaking. It's nothing like we've ever seen before. It builds on Fitzgerald versus Nixon, but it raises some questions in my mind, which is, for instance, as to the first category of absolute immunity, there's nothing more absolute than the president's power to grant a pardon. That's laid out in the Constitution. If the charge that wants to be brought by the Attorney General is that the president received a bribe to grant a pardon, would that absolute immunity apply? Sounds like it would, even though the president can be impeached and convicted and removed from office for taking a bribe. So I have a little bit of difficulty following that thinking. But I'll pass it on to our new common law professor.
Yeah. Professor Balakrishnan, do you have anything you would like to add on this one?
I mean, just briefly, I think that the only corollary that I could see, I mean, this opinion, I mean, I texted one of my colleagues that morning, is the Magna Carta going to stand today? That's how deep this cuts to our core of democracy, in my opinion. The only corollary I can see is prosecutorial immunity in the criminal side, right? But as was done in this case, this shifts then the burden to determine what is within the core of a prosecutor or executive's function and kind of what is the penumbra beyond that. And I think that is just going to be a messy, messy determination.
Well, just to be clear, where the court was drawing the line was the authority explicitly present in Article 2. And there are very few powers. When you read the Constitution, most of the attention is in Article 1 and some more in Article 3. And Article 2 is actually very brief. On the pardon power, just to respond to Judge Pia's statement, I actually think that even though the pardon power is an exclusive power to the president, in my view, if I were on the Supreme Court, the president's exercise that power for illegal criminal motivation, that would not be included. I think that, again, it's a matter of interpretation. Sotomayor brought up the question of whether the president could order the assassination of his political rival. And she said he'd be immune under the absolute immunity because he's the commander-in-chief. Well, the commander-in-chief is about as explicit an authority as one has, but if the president ordered the assassination of a political rival, I would hope the courts would step up and do something about that. So I think that no person is above the law and motivations in criminal law. And that's one of the more remarkable things about Trump versus United States. Not only did the court talk about the exclusive authorities under Article 2 and the delegated authority is from Congress and Article 1, granting authority to the president to exercise and take care that the laws be faithfully executed. The court also went on to say that the motivations of the president when it's within his or her power are not relevant and not admissible at court for fear that that also would intrude on the executive's functioning. So again, this case first of all, goes well beyond the facts of the case and goes well beyond, I think, the history and precedent and principle of the Constitution. I hope that we never have a president who acts in such a chaotic, anarchy-oriented fashion. And it's hard to imagine anybody having such poor judgment running for president, much less being elected. And of course, I am firmly have my tongue in my cheek. But this could be the death knell of our constitutional democracy. I hope it ends up being a complete sleeper, but I don't think that this former president would be at all deterred. And you have to think also on the pardon power. When you think about it, well, if you say, well, if SEAL Team 6 kills the political opponent, well, aren't they responsible? This is the Nazi regime question, right? Where the Nazis said, well, yes, I ran the camps, but I was just following orders. Well, the president is absolutely immune for giving those orders. Well, what about SEAL Team 6? What about the people that carry out those illegal acts? Well, if I were President Trump, I would pardon them, right? I just give them a full pardon. So this has impacts. And just one other thing, because I want to anticipate Roper Bright, the Supreme Court has been in the business of taking power away from administrative agencies, away from other authorities in our constitutional scheme. And when I first read Trump versus United States, I thought, well, this is interesting because they're really giving this enormous executive power to the president, which seemed inconsistent with other decisions where they arrogate to themselves that authority. But in the end, and I believe it was, again, Justice Sotomayor who made the point, it's the court's decision ultimately as to what falls within the immunity scope. So absolute immunity extends to the Article 2 authority. Presumptive immunity extends to all other official acts. Well, what qualifies as an official act and whether presumptive immunity ends up being the bottom line, well, who's that up to? Well, it's up to the court. So the court has great faith in its own ability to navigate the constitutional scheme and little faith in anybody else. And again, that's not what Marbury versus Madison said. That's not what McCulloch versus Maryland says. That's not any principle that I think that the founders would have understood or would have stood by.
Let me add just two thoughts, and then we're going to turn it over to Judge Bea. First, it's important to note that Amy Coney Barrett dissented on at least 3 of the central holdings of the majority in this case, particularly with regard to you can't question motivation, you can't use official conduct as evidence, even if you can't prosecute for the conduct itself. She said, this is a direct quote, "I disagree with that holding." So she's dissenting on that point. She says that in another footnote about another part of the decision. And the other thing is that Justice Sotomayor asked exactly the question that Judge Bea asked, which is, could you accept a bribe even for an official core constitutional act? And the majority did not directly answer that question. In fact, Justice Sotomayor in her dissent says, you haven't answered the direct questions. Can the president do this? Can the president do that? And what the majority said is we remanded to the lower court. And I'll just say to you that I published a little article on law.com about 2 weeks after this decision came out entitled, "If They Really Meant It, Make Them Say It." And this was directions, my instructions to the district court judge. She doesn't listen to me, but saying that it's her job to decide what of the now superseded indictment survives this opinion and what she ought to do. Because that's going to go back up to the Supreme Court automatically, unless Trump is the president and he squashes the prosecution. She ought to sustain the indictment and say, if you really mean it, that you can be immune even for grossly criminal motivation and conduct in the exercise of your power, then you really have to say it out loud and not just remand it to a lower court judge. So we'll see what happens on remand. Judge Shepkin is considering that right now. One of the questions is, will she release all the evidence that the prosecutor has now submitted under seal to support the new superseding indictment? And we won't know the answer to that, maybe before the election, but maybe not. We'll see. But we won't know what the Supreme Court thinks about it until well after the election. With that, Judge Bea only has 3 major constitutional decisions to discuss. And we're going to try to go case by case, so we may comment after each case, but Judge Bea.
Well, first of all, thank you very much for inviting me. It's nice to be back in a law school environment, and I can tell that you're all law students because nobody's sitting in the front row where they can be called on. The first case I want to talk about is City of Grants Pass versus Johnson. This is the case which allowed the City of Grants Pass to enforce an ordinance making criminal the camping or sleeping on public agency, public grounds. The case arose in district court in Oregon. The district court enjoined the enforcement of the Grants Pass ordinance on the basis that it was a violation of the Eighth Amendment. Cruel and unusual punishment is prohibited. Following the Ninth Circuit Court case of Martin versus City of Boise in 2022, which was not taken in bank and where a petition for certiorari was denied. It was the same issue as the Eighth Amendment, but they didn't take that one and they did take this one. So they granted certiorari. In a 6-3 opinion, the Supreme Court reversed the Ninth Circuit. That's not unusual. Justice Gorsuch wrote the opinion. And it was proceeded on these bases. The enforcement of generally applicable laws regarding camping and public property do not constitute cruel and unusual punishment prohibited by the Eighth Amendment. This is an application of Smith versus Employment, saying this is a generally applicable law because it applies also to college students and to hikers that sleep on camp, on public lawn. He said, the cruel and unusual punishment clause focuses on the question of what method or kind of punishment a government may impose after a criminal conviction, not on the question whether a government may criminalize particular behavior in the first place. So the question is, how can you punish? How, but not when can you punish or not. So then the big argument in the case was whether the status of the conditions of homeless people constituted a status similar to the status which was found in a case called Robinson from California in 1962 to be unconstitutional under the Eighth Amendment. A word about Robinson. Robinson was a prosecution under a state of California law which made it criminal to be an addict, a drug addict, not selling drugs, not taking drugs, not handling drugs, but being a drug addict. And in that case, a 1965 case by the Supreme Court, they found that that would be a violation of the Eighth Amendment. It would impose cruel and unusual punishment. Some years later, a similar case from Texas called Powell found that it was not a violation of the Eighth Amendment to convict someone for being drunk in a public place. Powell said, I'm an alcoholic. I'm always drunk. And I've got to be someplace. And the court said, we're punishing an act here, the action of being drunk in a public place. The big controversy in the case was between Justice Gorsuch, who I've already explained what he was saying, and Justice Sotomayor's dissent. Justice Sotomayor saw the punishment of homeless people who were sleeping on campgrounds as being similar to Robinson, a status crime. And she said, sleepy is a biological necessity, not a crime. And so to her, the issue was there's no act involved here which is being restrained by the public, by the criminal action. It's a status. Of course, it does take an act to go to a campground, just as it does to Mr. Powell. It takes an act for the drunk man to go to the public. So that was the basis of the distinction there. The defenses to a criminal prosecution, such as necessity or insanity or diminished capacity or duress, still exist. And on the remand of this case, that will undoubtedly be argued. So that's Grant Pass. The next case I want to discuss is a case that ended the Chevron doctrine of statutory interpretation, a disclaimer. In 2015, I gave a talk in Washington, D.C., and about Chevron. And I didn't like the Chevron decision. And I ended it by saying, let's junk Chevron. Well, it took some time, but the Supreme Court did it.
Judge, will you give us a shot at talking about the homelessness case before you
Oh,
move
sure,
on here?
fine.
Would that be okay?
Sure.
I know Professor Balakrishnan had a few things she wanted to talk about on this case, yeah?
Yes, sure.
And then we'll come back on
Sure.
Loper Bright.
Right, just briefly, I think that Grants Pass is interesting because I think it opens the door to a very dark road that we could walk through. And I want to point specifically to something that Thomas says in his concurrence. And he actually says that Robinson should be revisited. And I think that's a little crumb. And we'll also see this with Lopez Bright. There's these little crumbs that they drop in concurrences and that eventually create the momentum to overturn cases like Chevron, or in this case, potentially Robinson, which has stood since 1962. And the line that is drawn between a homeless person and the act of sleeping in public, to me, that blurs into status, right? It is different than somebody who is addicted and is under the influence of an intoxicant in public. And there are quite a few laws already that can be used that do not deal with the status of being homeless, but deal potentially with acts that are often correlated with homelessness, such as blocking access to sidewalks, that other such acts that we can use, public defecation, et cetera, that can be used that don't impinge on just the simple status of being homeless. Beyond that, I think that the case draws a very kind of maybe theoretical, but not reality-based distinction between involuntary and voluntary homeless, right? That's really what they're saying. Look, these people are voluntarily homeless. We have enough beds for them, but because these beds require them to go into a church and pray, or won't let them smoke in the shelter, they don't want to go there. So they're deciding to be homeless. And I think that belies the truth of homelessness. People become homeless for quite a few reasons, right? Climate change, for example. Think of our friends in Paradise, California, that went from being homeowners to homeless in an instant, right? Think of the mentally ill or people with disabilities, right? Sotomayor, and I recommend that you read her dissent. It is beautiful. She charts out only 5% of homes in America, not even shelters, homes, are equipped for disabled people with mobility issues, right? An increase of $100 a month will increase the homelessness rate by 9%. Right? So we're not dealing with saying that these people are choosing this and so we get to punish them. And that's the first point I want to make. That's not really what happens. Like, I mean, as a former public defender, I would visit my clients at some of these shelters and treatment facilities. And this one time I get there and they're all waiting outside in the rain. And I'm like, why are you guys waiting outside in the rain from the shelter? And they're like, well, they're spraying for bed bugs again. Now, if that person chooses not again, right? And I was like, again? If that person chooses not to go back into the bed bug infested shelter, are they voluntarily homeless? And so when you look at California itself and bringing it home to San Francisco, we are in the midst of this dilemma here and with our school here, right? We don't have enough shelter beds in San Francisco. The 3,000 people that are on the street, are they voluntary or involuntarily homeless? And to quote Sotomayor, to quote the Christmas Carol first, are there no prisons? Are there no workhouses? That's one of my dad's favorite movies, so I had to throw that out there. These institutions that we have, how well are they equipped to deal with this problem, number one? And then number two, to quote Sotomayor, what if every town, village, and city lacks the compassion and passes a similar law? Where are they supposed to sleep? And I think that is just kind of my initial response to Grants Pass. That, and as I said, the crumbs that were dropped by Clarence Thomas and his concurrence. I think Robinson might be the next to go.
So if I could, we sued the city and county of San Francisco in May 2020 over the conditions on the streets of the Tenderloin. You may remember that's when the pandemic really set in. CDC required or recommended that shelters be reduced from 100% capacity to 20% capacity. And as folks left the shelters, they were given tents by groups like the Coalition on Homelessness, And those folks then set up tents throughout the Tenderloin neighborhoods, including in front of 200 and our buildings. We went to the city. We said the hotels are empty. You need to give these people shelter, but they can't be on the streets. We have residents, including our students, who are having to step over people, or not able to have to walk in the street. There are people in wheelchairs. They can't get down the street. They can't get to the store. The city was, quite frankly, unresponsive, and we brought a federal claim. Judge Tiger was the judge and continues to be the judge overseeing that matter. He's a quite brilliant individual and has done everything he could to find a middle path, and that's the path that we were seeking as well. We are extraordinarily compassionate about the folks that are either involuntarily or voluntarily homeless. And I meet with the mayor's working groups. I meet with the mayor's office, the DA, Brooke Jenkins, the U.S. Attorney's office, the chief of police every other week to talk about the situation in the Tenderloin. And so I hear about people that say when they have a shelter, including hotels, they refuse to go. And I do consider that to be voluntarily homeless because they don't want to be supervised. And again, you have autonomy and you have a choice, but the residents in the neighborhood also have rights. There are single moms with 3 children, and you have congregations of 25, 30, 40 people right outside their window at 2:00 in the morning. And so I think Boise, with all due respect to the Ninth Circuit, was a very inappropriate vehicle for getting to where you wanted to get to with the Eighth Amendment. It was just too rough, a sword, or too blunt an object. And so I think that it's basically a political question, how you respond to what's happening on the streets. I don't think Robinson's going to be overturned. I think it's good precedent. I do think there are acts, and I think, again, you need to find an intermediate solution. So the people who live in the Tenderloin have rights to access to their apartment. They have the right to wheel a wheelchair down the street. And the people that are homeless also have rights to compassion and to resources and training and other things. I'll just stop by saying, in the bottom line, this is my personal opinion, we are not doing anybody any favors by letting them just stay on the streets, whether they are simply homeless, they have nowhere to go, and the city is not, the county is not giving them someplace to go, or they are drug addicted or alcohol addicted, or they are mentally ill. We are not doing them any favors by just letting them hang out on Jones and Turk. That is not compassion. That is not what a civilized society should do.
It's a fun role to be the moderator and have to interrupt the dean and a life tenured member of the judiciary.
Yeah, you're tenured as well, Rory.
I'm wearing that. Let me just say that Justice Gorsuch's opinion is not an inhumane opinion. And there is a footnote, and you do have to read the footnotes if you take my con law class, where he says there may be other ways to challenge regulation of the homeless, where he talks about due process, equal protection, selective prosecution, things like that. He's not heartless in this area. And I think this is a case where Judge Bea and David Faigman probably don't disagree as to the bottom line, which is the Eighth Amendment does not prohibit humane regulation of this issue. With that, Judge Bea, we toss it back to you.
Let's go on to the next case, which is the end of Chevron case. A word about Chevron for those of you who are not familiar with it. Chevron was a case that came down 40 years ago and involves the EPA. And the question was, what was a source of pollution for which a permit was necessary before you could make a change in the industrial architecture? And there were 2 theories about this. The Carter administration said a source is a single smokestack. And if you change a single smokestack, you need a permit. The Reagan administration said, no, a source is the overall plant where the pollution comes out of. And if your change doesn't change the pollution amount from the whole plant, then you don't need a permit. So the EPA, after Reagan won the election, went Reagan's way. And then the case came to court. The Chevron holding says that where a statute, in this case the EPA, what does source mean? When a statute is ambiguous or silent, or leaves a gap, then we look to the interpretation of the congressional statute by the agency that's tasked with carrying it out. And the idea was that the expertise of the agency would help interpret what Congress had left ambiguous or with a gap. That's gone, folks. That's over with. The facts in Loper Bright, you should keep in mind. Under the Fishing Act, boats in the Atlantic and in the Pacific have to carry observers to see that the fishing is done correctly for environmental reasons. But there are two kinds of observers, the kinds that are paid by the federal government and the kinds that are paid by the boat owners themselves. The Act of Congress says there are three categories of boats, fishing boats, that have to pay the observers. One is all foreign-owned vessels, right? Second is limited access vessels. Those are vessels that fish with limited quotas. So they have observers to make sure they don't overfish. And the third is North Pacific fishermen. So those are all laid out in the statute. Along comes some Boston Atlantic herring fishing, but not mentioned in those three categories. They say that doesn't apply to us, but the agency is making us pay $710 a day for the observer to be on our boat because we have to pay a salary, and that cuts into our profit by 20%. So the agency said, not to worry, we'll interpret the three that apply to those three categories to extend to Atlantic herring fishermen. So you pay up also, right? That's gone. The Supreme Court granted cert and wrote an opinion saying that the Administrative Procedure Act requires courts to exercise their independent judgment in deciding whether an agency has acted within its statutory authority, and courts may not defer to an agency interpretation simply because the statute is ambiguous. There were three reasons for that. Number one, Article 3, going back to Marbury versus Madison, it is emphatically the province and duty of the judicial department to say what the law is. Number two, since this was an agency, and the question was whether the agency determination that the boat owners had to pay the salary was an abuse of discretion under the APA, the Administrative Procedure Act, the court looked at Section 706 that states that all relevant questions of law must be decided by the court. And the third was that Congress may have intended to provide agencies to employ their expertise in policy-making decisions, but that idea, Chevron, had been devalued over the years by a series of Supreme Court cases involving major questions, which major questions were taken out of Chevron, and they hadn't cited Chevron since 2016. So Chevron is overruled. I don't know what the decision was vacated and remanded for trial in district court in Boston. I don't know what the result is going to be, but it's pretty clear if you apply statutory interpretation that three types of fishermen have to pay the salaries of the observers, and this one over here isn't one of those three classes, then maybe they don't have to pay. The dissenting opinion of Justice Kagan, and joined by Justice Sotomayor and Justice Jackson, relies heavily on the idea that Congress empowered agency to regulate their own tasks, and because they have expertise. They didn't discuss what expertise is necessary figure out the three categories and whether one is in and one is not. And then the other was stare decisis, and they made one point that bears thought, which is Congress can change Chevron, can change the ruling in Chevron and say, you can't do this anymore. And since Congress hasn't done it, why don't we allow Congress to do it? So that's Chevron. Chevron is dead. I hope it stays dead.
Can I just
resurrect Chevron?
David, let me just say one thing, which is Chevron is overruled, and there's no doubt about that. But deference to agency expertise is not overruled. And this is my pitch to all of you law students: take administrative law, because it's a vital topic in today's world with all of the regulatory efforts that are around. There is something called Skidmore deference. The court says we should still defer to fact-bound determinations. And let me just say, for those of you who want to put yourself into one political sphere or the other, you will be happy that Chevron has been overruled if President Trump is elected and starts to pass new regulations that you don't like. You will want to see courts independently review those regulations. If you happen to practice immigration law, you don't actually want expertise of the immigration service to control things. So it's not a single-sided sword, is all I would say. David,
I mourn
30 seconds.
I mourn for the death of Chevron. I somehow become the dissenting voice on this panel. First of all, I think that it does go back to this question, the non-delegation doctrine. It used to be prior to 1930. We're going back to pre-1937. Eventually, we'll have a Lautner decision if we haven't already had one. And this idea that Congress can't delegate its authority to administrative agencies to deal with the gray ambiguities of the statute, I think is misconceived. It's a misconceived understanding of separation of powers. Congress can revisit that question if it wants to, but Chevron, I believe, was a unanimous decision. So the Supreme Court somehow thinks it's a lot smarter than every justice that's ever come before, and is a lot smarter than administrative agencies. There's a wonderful moment in the oral argument in the case EPA versus Massachusetts, where Justice Scalia is asking questions, and he asked the attorneys for Massachusetts something about, hey, what are you doing trying to deal with the stratosphere? This seems to me totally inappropriate. And the lawyer said, it's not the stratosphere, it's troposphere, Your Honor. And he said, troposphere, stratosphere, whatever. I'm not a scientist. I shouldn't have to deal with these issues. I think to Rory's point, it's true that technical expertise is still part of the administrative agency function, but I think what's being misunderstood is the relationship between technical expertise and statutory interpretation. I think there's a lot more that is involved there that needs to be resolved. And I think quite fundamentally, in fact, I will be giving a talk at Columbia University next month. I was invited by their Science Technology Law Review to talk about judicial competence in understanding science. The title of my article is Judicial Innumeracy, with present company accepted. But the fact of the matter is, the reason why people go to law school is because they're not good at math and science. And the reason why people that are lawyers become judges also is because they're very good at lots of things, but not necessarily math and science. The reason why the EPA has a scientific advisory committee is because the scientific advisory committee is made up of people who are very good at math and science. The idea that judges, Trump appointed or otherwise, would be making these decisions, quite frankly, I find frightening and likely to lead to all sorts of terrible decisions. And maybe to Prithika's point, it may lead eventually to the death of the or the revival of the non-delegation doctrine, where Congress can't give any power to administrative agencies because it's considered to be an Article I power.
Let me just say that Judge Bea is really good at math. He ran a very successful business for decades here in San Francisco. Go ahead,
Sure, I
Prithika.
just wanted to just briefly insert a little bit of realpolitik into this decision. There was a lot of clinking of glasses on yachts this summer. This was billionaires and other such interests really benefited from a lot of the decisions that were made. And I'll be talking about one, Jarkissi, in a minute. But specifically,
If we get there.
the fishermen, this program actually ended before the Supreme Court heard the case. And the litigation itself was funded by the Koch brothers. So the question is who is benefiting from the kind of kneecapping of the administrative state? We see it in this case in Lopez v. Bright. We're also seeing in Jarkissi if we get there. So that's a question just to keep in mind as you're ruminating and as law students reading the nuts and bolts of the analysis, also kind of just taking a step back and seeing kind of who the players really are and who's benefiting.
Judge Bea, you have one more case.
Yes. The last case is a case of U.S. versus Rahimi. And here the Supreme Court reversed the Fifth Circuit, which is unusual, and affirmed the conviction of Rahimi based on his possession of a firearm while Rahimi was the subject of a state court entered domestic violence order. Under 922G, 18 U.S.C. 922G, a person who's under a court order for domestic violence to restrain from domestic violence cannot have possession of a firearm. The court's holding, this was really the first decision after New York versus Bruin regarding the Second Amendment rights and possession of guns. So the court's holding was when an individual has been found by a court to pose a credible threat, when found by the court, a credible threat to physical safety of another, that individual may be temporarily disarmed consistent with the Second Amendment. This Rahimi was a sort of an easy case for the application of this doctrine because Rahimi was really a scoundrel. Not only was he under this court order that he not beat up on his domestic partner, but when there were several occasions where he pulled out his gun and shot it in the air and scared people away when they tried to come near him. So the sole dispute in the statute really was not whether Rahimi had a right to possess a gun under the Second Amendment. It was an arm, it was a weapon, right? The second step in Bruin was whether the regulation was consistent with the principles that underpin our regulatory tradition. And here is what's going to happen in all these gun possession cases. It's going to be, what do you determine to be the historical tradition of our regulatory history or tradition? The court said, if the regulation may not match exactly the historical precursors of weapon regulation at the time of the founding or even at the time of the adoption of the 14th Amendment, but if it's, quote, analogous enough, it may pass constitutional muster. So the question is, what was analogous enough? The majority said, we go back to colonial times and founding times, and we find two kinds of weapon regulation. Number one are the surety laws. In Massachusetts and New Hampshire, a person could be brought up before a court, and upon proof that he presented a danger to others, he could be made to put up a a surety bond of a certain amount, which will be forfeited if he misbehaved. That was surety cases. And as far as the second basis, the common law, there were affray laws, which said, going back to 1320, that persons could not ride armed and scare the good people of England or Massachusetts. And those two were the basis of the comparisons that the court found here were applicable. Now, mind you, under the surety laws, person who violated the law, the surety, didn't have to turn in his gun. That wasn't part of it. And of course, once the time was over, or because they were all time limited sureties, he could have his gun back. And as to the affray issue, as a comparator, all affrays took place in public, not in private. So the question was, is this really a good comparison? The court found that there were good comparisons and found that the statute was good. The dissent, pardon me, before we get that, we're told not to pay attention to concurrences, but the concurrence of Justice Gorsuch made it clear what was not decided because the case did not present it. He says, whether a person can be disarmed without a judicial finding he poses a credible threat of physical injury to another was not decided. That meant something to me because I wrote an opinion in Rory versus USA saying that 922(1) or G1, which is felon in possession of guns, was unconstitutional, but you can relax as Ninth Circuit has taken the case in bank. But I thought that was interesting. And he also said, this decides only that the government can disarm a person under penalty of criminal law temporarily, not permanently. And it doesn't decide whether the gun possession prohibition could be enforced against a person using the weapon in self-defense. And it doesn't define any other group subject to a categorical basis. The concurring opinions are worthwhile reading. I think what's going to happen in these cases is the turning point will be what's analogous on a historical tradition and what isn't analogous. And Justice Jackson, in a concurrence, made the point, I think, very well, saying a particular case seems to depend on the suitability of whatever historical sources the parties can manage to cobble together, as well as the level of generality at which a court evaluates those sources, neither of which have we adequately clarified. So that's where we are now. Single dissent by Justice Thomas saying the statute is unconstitutional based on his analysis of Bruin.
Right.
First.
I think we're going to just go on to the next case so that we have time for Professor Balakrishnan for 2 minutes. Thank you, Judge Baya.
Sure. I mean, we can circle back to Rahimi because it's a fascinating.
We're gonna stop in, let me just say, 7 minutes.
Oh,
So that we
wow.
can take
Okay.
questions from anybody who's left. I know a lot of people had to go to class.
Okay, ask me what I think about Rahimi. So Jarkissi rhymes with messy, and it is a mess. That's actually, his counsel actually said that's how you pronounce the name. Jarkissi versus SEC. So this is a 6-3 decision. The Supreme Court ruled that Securities and Exchange Commission cannot use its administrative courts to decide securities fraud claims seeking civil penalties. That the Seventh Amendment entitles the defendant in that situation to a jury trial. So my interest in this, as a criminal law scholar, really has to do with the right to jury trial. That's fundamental to criminal adjudications. I found that to be really the only time when the defense was on something closer to a level playing field was when the jury was in the room. And obviously the Sixth Amendment grants defendants in criminal cases a jury trial. And the Seventh Amendment states that for suits at common law, if the value in controversy shall exceed $20, the right of trial by jury shall be preserved. So Jarkissi requires a jury trial for civil cases where penalties are awarded. So as a fan of juries in criminal cases, what's my thought on this? Is this a good thing? So coming from the Seventh Amendment and looking at kind of historical sources. At the time that the Constitution was written, the right to jury trials in civil matters and criminal matters were regarded as relatively equally important. And you can see that the same concerns that inspired the desire to protect civil juries and criminal juries were very similar. Democratization of decision-making, a check on government power, and as Tocqueville wrote, a way to educate the constituency, to have them be involved in civil governance. So these were all good things. And it didn't matter in the founding era, both civil and criminal juries were held to be equally important. So with that background, let's jump into the Jarsky case. So George Jarsky is a right-wing commentator. He's a hedge fund manager, and he ran a fund where they dramatically overvalued the value of the fund to get more fees from their consumers. So it was fraud. And the SEC launched a fraud investigation against him. Now, the SEC was created under the rubric of the Securities Administration Act of 1933. It was then, after the Great Recession of 2008, Dodd-Frank kind of made some changes there to allow the SEC to be more agile in how it responded to fraud. One of those changes was to allow this type of litigation where the SEC was investigating fraud with the potential of civil penalties to be assessed, that they could keep that in-house. They didn't have to go to a federal court with the jury to run that case. They could have their own administrative judge review it. So that's what Dodd-Frank does. And essentially, this case overrules that. And the ruling here is that in any cause of action that would have been historically categorized as a matter of common law, the individual, the defendant, has the right to a jury. SEC fraud is based on the common law fraud concept and statutes, and the court says it's that simple. If it's a common law antecedent, you get a Seventh Amendment right to a jury, and that's what this is. So great, but what really is happening here? Because what this is yet again another missile at the heart of the administrative state. Once again, we hear the clinking of champagne glasses on yachts. Because what's going to happen here is we're not going to see a bunch of jury trials pursuing fraudsters in securities actions. There just isn't that level of resource. What we're going to see is those fraud cases not being pursued, right? And that just and this is again, Sotomayor has the word on this. This isn't just the SEC. There's over 200 laws with similar structures and over a couple dozen agencies, right? We're talking about the the EPA, the FDA, the NLRB, right? So this is essentially an end run against enforcement of these types of statutes. Again, let me tell you who funded Jarsky, Musk, and Mark Cuban, the Mavericks guy, right? So they have if you remember when Musk was on the tweets doing his thing about, there was a challenge brought to him by the FEC saying, and he asserted First Amendment rights, right? Apparently he should have asserted his right to a jury trial under the Seventh Amendment. So the lack of in-house apparature to deal with these types of issues is going to essentially make the administrative state unable to function in the way it has been now since the New Deal. And I think that's going to be a very interesting outcome. Now, just a couple more points on this. Great, everyone gets a jury trial now, but we really recognize that we're not going to have these jury trials. But who's left out, right? Who doesn't get more judicial process? Well, the Seventh Amendment applies unless there's a public right exception to the Article 3 rules. So what does that mean? There have been things that have been determined to be exclusively in the executive and legal branches control, right? So you will not see, right, as a result of Jarsky, moving immigration out of immigration courts inside the administration, immigration laws, Indian tribe laws, granting of public benefits. Those will all remain administrative court matters. What we will see, though, is things like the Clean Water Act, right? The levels of lead in our water, fraud by pursued by the SEC. Those are the claims now that we are not going to be, there's not going to be any sort of real process around those, because it's just going to be not viable for these organizations and for these agencies. I also want to say that a lot of these cases are giving more, not only are they reducing the size or the power of the administrative state, they're also giving more power to the courts, right? And so when we think about why and how that's happening, why at this moment are we giving our certain interests of a certain political leaning interested in giving more power to the courts? Well, Trump has now appointed over 200 judges during his presidency with lifetime tenure. The Supreme Court now has several additional Trump appointees that will be there probably for the rest of my life, right? So when we think back as to why certain political positions are more interested in having judges make decisions, I think that that can't be silenced either. I can go on to my next case, but I want to leave some room for comments.
So we're going to shorten what we have to say, because I'm going to assume that there may be some questions out there. If not, we'll come back. Let me just say, without responding on jargony, it was surprising that they didn't go with the public rights exception with regard to securities laws, because securities laws, of course, didn't exist until they didn't exist as common law causes of action for the Seventh Amendment. This case Erlinger, let me just say about Erlinger, there are two things that are important to say. The majority in this case says, without giving you the context, that every fact essential to an offender's punishment must be found by a jury. The Supreme Court has never said that before. Every fact essential to an offender's punishment. Anybody who's ever been a criminal lawyer, me, Prithika, anybody else, every fact is essential to your client's sentence. And this, if this sentence were taken literally, it would give a jury trial to sentencing in every criminal case, which we cannot possibly support. And nobody has noticed this yet, and nobody's quite sure did they really mean it, but they said it. The other thing I'll say is Justice Jackson dissented. Ketanji Brown Jackson, the former public defender who's now on the Supreme Court, she dissented, as did Justice Kavanaugh, who is not linked in arms in many cases with Justice Jackson. And Justice Jackson cited one of my articles from 2000 and 2005. So, you know, I think she's right. And I'm going to say about the coming term, the biggest cases for the coming term are going to be ones you haven't seen yet, because they are going to be related to the election. And there's where you're going to see emergency appeals firing up to the court from both sides, I think, within days of the November 5th election, unless things are a lot less close than it looks like they're going to be. And the other case that hasn't been filed yet is the appeal from whatever Judge Chutkan does in the presidential prosecution of Donald Trump. If she sustains that indictment, that's going to go up to the Supreme Court unless somebody squashes it. And the last thing I'll say is next Tuesday, there's an argument about whether weapons parts, kits, can be regulated as firearms. Kits where you can make a gun. There's a video I have that shows making an AR-15 in a 30-minute span from one of these parts kits. Can you regulate that as a firearm? And then the next day, next Wednesday morning, a case called Glossop, where the Oklahoma State Attorney General has filed a brief saying we concede error. Glossop was denied due process. He should not get the death penalty that he has currently. And the Court of Appeals in Oklahoma said, we don't care what the state attorney general said. We affirm his death penalty. And the Supreme Court has granted cert on this. Oklahoma's not defending it because they think it's a violation of due process. So the Chief Justice has appointed a former law clerk to be the amicus who will argue the case. That'll be an interesting argument next Wednesday. Mm-hmm. With that, I'm sorry, Prithika, but we're going to ask our questions. If there are no questions, we'll give the stage back to, yes. Can you come to the microphone if possible? Thanks. And short question, and maybe tell us your name.
Hi, yes, Professor Joe Kreitz. A number of recent Supreme Court decisions, including several that you all have discussed, seem to really elevate the role of history in constitutional analysis. And what we've seen in these decisions is that judges and Supreme Court justices in particular, and Justice Alito in particular, are horrible at history. How are we, those of us who are practitioners, to handle the litigation of issues that implicate historical analysis under the US Constitution, when historians, academic historians, are not generally accustomed to operating as expert witnesses, and there's no guarantee that the courts are going to read the history accurately when they get it anyway.
Good question. Judge Bay, do you want to respond on history or?
You have to pick your historian if you want to win your case, right? And the issue hasn't come before us yet, but can you hire an expert witness to be a historian and give his opinions? Remember what Mark Twain said, an expert witness is a prevaricator a long way from home.
So I teach evidence. The answer is yes. Not only can you hire an expert under Rule 706, which would be a court-appointed expert, but you can hire what would be called a technical advisor under Rule 104A of the Federal Rules of Evidence, and most states have a corresponding rule. A 104A expert, and actually the way it's practiced in the Ninth Circuit, is not subject to deposition, is not subject to discovery, and basically sits at the elbow of the district court judge. I believe the Ninth Circuit could, at the appellate level, could also hire technical advisors if they wanted to, and then charge the parties for that. I agree with the premise of your question. None of us are good at history. If you're asking what was the original intent, is it the original intent of the Virginia ratifying convention or the New York ratifying convention? They had very different views of what was happening in 1787 and in 1789. And you know, I just have to say, I find the court's Second Amendment jurisprudence stunning. I would be perfectly fine in looking at historical analogs in 1791 when the Second Amendment was ratified or adopted by Congress. If you go back to 1791 and ask, well, what kinds of guns were they regulating? And limit it to, muskets, that's right. And so the idea that you only take one side of the equation and ignore the other side, of course they weren't thinking about semi-automatic weapons in 1791 or improvised explosive devices or anything else. It's completely insane. 100 years from now, historians look back at this time on the court and just wonder who these individuals were. And I think it goes to the point you have to look at who's winning and losing in the end. And a lot of this is just politically driven, which is unfortunate because, when Justice Kennedy came to dedicate actually the building that was here before this building, he said, all we have is legitimacy. That is a product of our judgment. And I fear that that's what we're losing in the law today.
Do you want to?
Just briefly,
And then we'll go to this question after you.
Absolutely agree. I am hopeful, just barely a little hopeful, that Rahimi might be the high water mark because Bruin was just crazy, right? It required essentially historical analog that would be so precisely the same that you get to Rahimi, which was not a cherry picked case, right? It was a public defender case. And that they couldn't allow the historical pure originalism result, right? So 2 years later, right, they scale back Bruin. And of course, the one dissenter is Clarence Thomas, who wrote the Bruin decision, right? So hopefully we're pulling a little back. In the opinion itself in Rahimi, they say we don't have to be a historical twin, right? Not twinsies, but like not analog necessarily, but something principles. But there was no domestic violence statutes, right? Women did not have equal rights at that point. So what we're talking about sureties now? That's not it's kind of almost collapse. The originalism's theory kind of collapses in itself, and hopefully let's hold on to Rahimi and maybe we can scale it back just step by step. We'll see.
Having served as an expert witness many times, all I can tell you is there's always an expert on the other side, which makes it all a bit of a charade. Your question.
So my question is, I guess, for the left side or right side of the panel.
Pick up the microphone again.
Just speak right into it.
Is that better?
Yeah, a little bit closer.
Okay.
Yeah.
So sorry. My question is, in regards to Grants Pass, the laws that were challenged there were on the books since the 1600s, since the adoption of the Eighth Amendment. And yet they were challenged by the city with the argument saying that no matter what process a state takes, a government takes, you cannot punish certain I guess in this case, conduct, right? So my question is, to me, that sounds like substantive due process by a different name. And I guess why are we seeing so many cases where people are essentially asserting constitutional rights in efforts to limit states from regulating certain things that these plaintiffs might not be able to win through legislation?
That's a big question. Why do we see so many efforts to use the Constitution to block state efforts? I guess my response to that is going to be, boy, history. The Bill of Rights was written to restrain the states. To restrain the federal government, but then in the 14th Amendment, we say it's restraining the states. The history of the Civil War is to restrain the states. And I guess I think that's how you use these substantive amendments to restrain the states in their regulatory authority. But what you have to do with those amendments, right, they're all vaguely written. They're all general propositions. I think it's hard.
Go ahead.
I mean, I think it's a great question.
He's talking about
the bottom
grants
line
passed
is
and the homelessness.
the government sometimes acts that infringe liberty, and liberty is exercised through either explicit or implicit provisions of the Constitution. Historically, we used tiered scrutiny to do that kind of analysis because, on the one hand, you have the government's interest and legitimate regulatory actions, and you have the individual's right to speak. So if you are speaking that may result in inciting violence, you have a right to speak, but the government has a right to shut you up if violence is, going to be imminent. How you draw that balance and where you strike that the relationship between government power and individual liberty is ultimately a judicial decision, and that ends up being the substantive due process analysis as well. And that used to be the Second Amendment analysis too. Second Amendment analysis was a tiered scrutiny analysis, and Thomas just threw it out in Bruin with no basis whatsoever.
Let's do the last question of the day.
So can I ask a question that does not involve a Supreme Court case, but does involve a recently decided Ninth Circuit case, since Judge Bea is here?
I mean, those questions.
He's talking about a Ninth Circuit case, apparently.
Yeah, I wanted to just ask about a recently
Could you
decided.
pick up the microphone and put it closer to your mouth so I can hear you?
Very sorry. I wanted to ask a question about recently decided Ninth Circuit case, Apache Stronghold versus United States, which overturned Navajo Nation's standard on RFRA and instituted a new Ninth Circuit standard on that. And I wanted to ask mostly Judge Bea's opinion on the new standard and what that would mean for religious freedom in the Ninth Circuit, both within the case of Native American sacred sites and more broadly.
I think you're talking about Stronghold, right?
Yes.
All right. My opinion was based on what I had written 15 years before Navajo Nation, which was that the way I interpreted the statute, RFRA, it provided two ways that constituted a substantial burden. If you'll note, I was in dissent in that case. The majority disagreed with me, and they say they reversed me by decision. My footnote says I didn't quite do that, but I think the only way you can understand that case is it's a tedious way, but you've got to read it from beginning to end. I can't tell you anything more than I don't know that the Supreme Court will grant certiorari in that case, and they haven't yet, although I think that there's been a request for certiorari. And if they do, it's going to be a very difficult question to put, because what is a substantial burden? Is it based on the precise definition of a substantial burden in the statute, or is it just a general concept of what is a substantial burden on a particular religion? That's what it's going to be.
We don't often get a judge to come here and actually talk about a decision that they have been part of. So thank you, Judge Bea. Thank you all for sticking it out. Thank you to the panel, and we'll see you next year.